Good evening, everyone, and welcome to this webinar on Coparcenary under Hindu law, an overview of the recent amendments. My name is Maitreyi Upadhyay. It's my honor to be introducing my co-presenters, Krishan, Kumar, Garg, and Samyuktha Pentyala. I hope you find this webinar conducted by the Law Gurukul as an initiative to spread legal awareness helpful and understand the importance of coparcenary in the Indian legal system. So beginning with the introduction. Black's Law Dictionary states that co-partners are individuals to whom an estate of inheritance passes together jointly and by whom it is held as a whole estate. So now what exactly is co-partnery? Co-partnery is a legal term that is referred in matters of Hindu succession law. It implies to a person who by birth is capable of assuming a legal right to the ancestor's property. Unity of title, possession, and interest is what it signifies. It is exclusively a legal formation. It cannot be created by parties acting together even through adoption. It is based on the Hindu concept and practice of the Hindu undivided family. Since the beginning of time, all property rules have been framed primarily for the advantage of men, and women have been viewed as second class citizens who rely on male assistance. The right to property is critical to a person's independence and growth. Prior to the Act of 1956, Hindus were administered by Shastric and customary rules, which differed from area to region and sometimes on a caste basis within the same region as per the Hindu Succession Act of 1956. Now, basically, there were two schools of Hindu law. Different schools of thought evolved as a result of the formation of distinct commentary on Smriti and Shruti. The first was the Mitakshara school. The doctrine of survivorship, the property after the death of the common ancestor devolves by the survivor. The sons of the family have a birthright in the property by virtue of the following two rules. Females will not inherit the property, and agnates were to be preferred over cognates. Coparcenary was that all the members of the joint family enjoy coparcenary rights during the father's lifetime. Now, the second was the Dayabhaga school. This school is based on the principle of religious efficacy or spiritual benefit. The ones who confer more spiritual benefit is entitled to inherit the property in comparison to those who confer less spiritual benefit on the principle of oblations. The females in the family may not inherit the property, may also inherit the property. According to this school, the sons do not have a birthright to the property. In the event of the copartner dying issueless, his widow has a right to succeed to his share and to enforce a partition on her own account. The coparcenary in this school is that it is not possible under the Abhaga school, as the father has overall and uncontrolled power over the family property till the day he dies. Further, Samyukta will take over the PPT and share her views on the topic.
Thank you so much, Maitreyi. Good afternoon, everyone. I'm Samyuktha. I will be speaking on the history of law of inheritance and also the amendments within the Hindu law. History of law of inheritance. The concept of coparcenary originated from ancient Hindu jurisprudence and became an essential feature of Hindu law. Traditional Hindu law is one of the oldest personal law systems. Hindu law considers the Vedas to be the most ancient sources of law. Vedas were the source of Dhamma, which refers to a person's moral, social, and legal obligations which he or she is expected to abide by and follow according to the ancient Hindu jurisprudence. Within the Hindu laws, all the laws and provisions regarding the property and its rights have been always male-oriented. They were exclusively framed for the benefit of the men of the family, while women were always considered submissive. Before the advent of Hindu Succession Act 1956, people were governed by their customary laws, which varied from region to region and also differentiated on caste basis. These laws were known for the gender discrimination. The proposed law could not be spread throughout the country due to lack of means, hence it saw variations in its practice in various regions. This led to different schools of thought and different practices, which made the law further complex and off track. The law commonly faced gender inequality in all practicing regions. There are some other laws prior to the Hindu Succession Act 1956. The first one is the Hindu Law of Inheritance Act 1929. It was the first legislation to bring a woman into the scene of inheritance. This act conferred rights of inheritance upon 3 female heirs, which are his son's daughter, granddaughter, and sister. The second one is the Hindu Women's Right to Property Act of 1937. It was a landmark legislation conferring ownership rights of women. It was a defining moment in the history of women's property rights. It was one of the first acts to grant women the right to ancestral property. This law brought about major changes in the then followed customary laws and schools of thought. It also affected coparcenary laws, partition laws, and laws of property, inheritance, and adoption. It also took into account the rights of widows and divorcees. Prior to this law, there were no codified laws to deal with the problems and disputes which were resolved using customary practices. This act was passed after much voicing of discontent over the unsatisfactory condition of women's rights. However, it was by no means enough to achieve the lofty target of gender equality. The Hindu Succession Act 1956. It was focused upon providing equality as stated by Article 14 of the Constitution of India. The idea of the limited estate as propagated by the Hindu Women's Right to Property Act was abolished in 1956 by the introduction of this act. This act tried to uplift the position and status of women in the society by providing them with the inheritance of share in their father's property. Daughters were declared as legal heirs of their fathers and received the rights of inheritance of a share of the separate property owned by the fathers through the notional partition. The ancestral property owned by the family would still be legally inherited by the son of the family, and the daughter would have no rights over it, thereby following the rules of survivorship. This led to the continuity of inequality, but at a slower or lesser diminishing pace. Amendments within the Hindu law. It was observed that the legislation made on the topic were not able to serve the purpose of equality and hence required to be modified according to the changing needs of the society. There were further changes made to incorporate daughters within the ambit of property rights, but nothing major could be achieved. In 2000, the Law Commission report suggested reforms with regard to women's right to property. It pointed out all the clauses which supported bias towards the males and suggested significant changes to be made. The Hindu Succession Amendment Act 2005. It was passed to amend the Hindu Succession Act 1956 to eliminate gender discriminating elements. The Hindu Succession Amendment Act 2005 was enacted with the aim of expanding the rights of women and daughters of the family and bring them at par with the male members. It followed the suggestions provided by the Law Commission report. By the way of this amendment, the daughters of the family, whether married or unmarried, gained coparcenary rights with the other entire rights and liabilities equivalent to a son. This now meant that the daughters would also be liable for the debts and losses in addition to property shares and other rights. Section 6 of this amendment challenged the fundamental principles of Hindu coparcenary law. Through this amendment, daughters, both married and unmarried, were given equal rights over the coparcenary as the sons of the family. It also provided that the females of the family could now also act as the karta of the family, which they couldn't previous to this law. Any reference made to a coparcener would also include daughters equally. Any property inherently entitled by her would be under coparcenary ownership and would not be disposed of by testamentary disposition. The amendment of the Hindu Succession Act in 2005 brought forth the rule of succession overrules the survivorship. Prior to this amendment, the daughters and other female relatives of the family were only considered as heirs and were entitled to their share of notional partition only after the death of the karta, while all the male members were eligible to acquire their shares even before the karta's death because of the rights of coparceners. This was the rule of survivorship. This rule basically means that only sons of the family could inherit property by coparcener rights because they were considered responsible for the further survival of the family name, while the rule of succession implies that property would be inherited by the order of birth irrespective of gender. This rule was introduced by the 2005 amendment and thereby included the daughters of the family within the coparcener rights. This amendment yet does not provide a completely fair chance as there are still provisions which have not been brought at par with equality, like after her death, all her property is to be owned by husband's side of the family. Further, Krishan will be speaking on the rest of the topic and will conclude our presentation. Over to you, Krishan.
Thank you, Samyuktha. Now I'm going to discuss some of the landmark cases and the judgment. So firstly, the cases of Prakash and others versus Pulvati and others. Pulvati sought partition and separation of her father's property. During the course of this lawsuit, the amendment was enacted, and the question was whether it was retroactive. The Supreme Court ruled that daughter would have a coparcenary right on and from the start of the amendment. clarifying that the amendment is prospective in nature, meaning that the entitlement to coparcenary property would be available only to living daughter of living coparcenaries, on and from the outset of the amendment. Next case is the Vinita Sharma versus Rakesh. On 11th August 2020, the victim in this case died before the act took effect on 20 December 2004. This is meaningless plus irrelevant though because the act is retroactive. It will not take away any existing right or entertainment. It was also established that daughters had a title to property by birth after Prakash versus Pulvati judgment was overturned. Next is the case of Shalini Sumant Raut and others versus Milan Sumant Raut and the others. In this case, Rajaram succumbed to death, leaving 8 heirs, which include 5 boys and 3 daughters. His inheritance was divided by estate succession, as defined by Section 8 of Hindu Succession Act, rather than by swagership. The application would have to examine the 3 female successors and their portion of the property through a notional division. It was decided. They will also have to think about the hypothetical partition that would occur if this co-partner died and left female heirs in the future. Next is the case of State of Maharashtra versus Narayan Rao Sham Rao Deshmukh and others. Here the court ruled that a Hindu co-partnership has a narrower body than a joint family. Only males who have an interest in the joint or co-partner property since birth can become member of the co-partnery or co-partner. Co-partners are basically male members of joint family, including their sons, grandsons, and great-grandsons. It has one common ancestor and a maximum of 3 male descendants. In the case of controller of a state duty versus Satyaprema Manjunatha Govada, the court stated that while a son, grandson, and great-grandson are all co-partners, the great-great-grandson cannot be included in the co-partner estate. The future of co-partnery and overview of recent amendments. As we have gone a long way from where we started, but there is still much work that must be done. Despite the passage of Hindu Succession Act of 2005, there are still certain inconsistencies in the law. The future of co-partner license going forward and enhancing the status of women by putting the following irregularities in the Hindu Succession Act 1956 into force. Anomalies that are still persisting in the present times are since the co-partner share of the deceased male from whom they inherit may drop, making daughters co-partners will reduce the share of the other class 1 female heirs, such as deceased widow and mother. In states like Maharashtra, where the wife receives a portion on partition, the widow's potential share will be now equal to the sons and daughters' share. However, in the state like Tamil Nadu or Andhra Pradesh, where the wife does not receive a share at the time of partition, the widow's potential share will be lower than the daughter's. Male co-partner remains a key right. The law now that provides for an equal division of the male co-partners upon his death among all heirs, male and female. However, the law places male offspring on a higher footing by providing that they will henceforth inherit an additional defined portion in co-partner property beyond what they could acquire equally with female heirs. The very principle of the co-partner is like an inclusive male membership club. It also partly limits one's right to will. Several European countries have similar restrictions. Otherwise, wills frequently dispose women, leaving them with nothing. However, because the 2005 Act does not respect testamentary freedom, keeping the Mitakshara system in place and making daughters co-partners, while not perfect, does give women the guaranteed participation in the joint family property. Whenever a Hindu woman dies without a will, her property passes first to her husband's heirs, then to her husband's father's heirs, and finally to her mother's heirs. As the ancient Hindu woman's property remains under the husband's name. Conclusion. In a society like ours, where male controlled ideals still dominate women's economic and social lives, law should serve as a stepping stone rather than a barricade to overcome these obstacles. Over time, the law governing the co-partneries were combined into household has changed. Various co-partner laws were enacted prior to the country's independence. The Hindu Succession Act of 2005 was enacted in 2005, marking the most significant change since independence. The Hindu Succession Act was transformed by this act, which gave women same right as men. Women now can become co-partners as well. It is important to note that if equality exists only as a phenomenon outside the population's awareness and approval, it can't be attained by a group of women socialized in oppressive traditions. As a result, there is a need to raise social awareness and educate individuals in order to modify their attitude about gender equality. By adopting a consistent law, it is also necessary to lay emphasis on changing social attitudes in favor of equality for all. The mandate task of putting the 2005 Act into persist. Campaigns for the legal education, attempts to raise social awareness of the benefits of women owning property for the entire family, social and legal aid for women wishing to exercise their right are just few numerous steps required to implement the exchange. Thank you.
Thank you. I hope this webinar has been helpful. I'd like to take this opportunity to also thank Krishan and Samyukta for such an insightful presentation. I am Maitreyi Upadhyay signing off. Until next time.